Hello, everyone. Thanks for attending our webinar on the California Consumer Protection Act. I'm Danielle Urban. I'm a partner in the Denver office of Fisher & Phillips and a member of our firm's privacy group. And I regularly work with clients on data breach and cybersecurity issues, privacy compliance, and in particular, helping clients to comply with U.S. Canadian data privacy laws as well as GDPR compliance. My co-presenters are Usama Kaf, partner in our Irvine office of Fisher Phillips, and Usama represents employers in matters of workplace privacy, data security, unfair competition, trade secrets, and corporate espionage. Usama is a member of the firm's Electronic Discovery Committee and has co-authored a book on e-discovery practice under the federal rules. He regularly advises clients on preventing and responding to data breaches in compliance with privacy laws. Usama's clients include staffing agencies, PEOs, financial manufacturers, distributors, and nonprofit organizations. And last but not least is Mitch Tannenbaum. He's a partner in CyberCecurity LLC, full-service cybersecurity firm based in Denver, Colorado. We work with them quite a bit. Mitch's background includes being the Chief Technical Officer for Texas Instruments, Defense Systems, Information Security Officer for several companies. Mitch has been the partner in several cybersecurity software firms. So thanks again. I want to remind everyone that we're offering SHRM and HRCI credits for this webinar in case anyone would like those, and certificates for those will be mailed after the presentation. So, California will be breaking new ground in privacy regulation isn't surprising. In 2004, the California Online Privacy Protection Act went into effect as the first U.S. state law requiring website operators to post privacy policies describing their information handling practices. So with that, I'm going to turn this over to Mitch, and he's going to get us started with the interesting background on this law.
Good morning and good afternoon to people, depending on where you are in the country. Thank you for joining us. We appreciate your time today. I hope this will be valuable to you. Next slide, please.
Okay, and Kayla, okay, there we go.
So
where you want to be in the next slide?
Yeah, this slide's good. So, one of the things that's sort of interesting in the world of cybersecurity these days is that many people, and here's a quote from Christian Nielsen, our Secretary of Homeland Security, earlier this month, cybersecurity is becoming a bigger threat, many people say, than the threat of physical attack. As a result of that, every state and many countries have been actively working on enhancing their cybersecurity and privacy regulations. Next slide. So this particular bill has an interesting has an interesting history. There's a real estate developer named Alistair McTaggart who self-funded a ballot measure for the California ballot that would have gone on the ballot this November that proposed an even tougher law than the one that was passed. Next slide, please. The legislature decided that that in order for them to have a say in what this law looked like, they needed to go off and dust off a bill that had been roaming around the legislature since early 2017 and pass it in the period of about 5 days. The reason why they did this was because if the ballot initiative passed and it looked like it was likely to pass, it requires a supermajority for them to make any changes. That in today's day and age is a very difficult thing to do. We've already seen, and I'll talk about it later, that they've already passed a series of amendments to this law, even though it doesn't even go into effect yet. So they wanted to have a role and a say in things. Next. And as I said, they claim that this was a last-minute decision, or some people claim it was last, but in reality, if you go look at the bill in the legislature's website, it was introduced in February 2017. And with that, I'm going to turn the slides over to Danielle, talking about who does this protect.
Well, and I just wanted to note that, to your point, Mitch, yesterday it looks like congressional leaders met with businesses to talk about passing some kind of a federal data privacy proposal. I know that since the time that the CCPA was signed into law, officials have held something like 22 meetings with over 80 companies to try to come up with some kind of federal data privacy proposal, and that would be regarding data collection and subject access rights. they've already been pushing for some type of federal action for some time, just because it's such a headache to comply with 50 different state laws. I think an important thing to note, though, Mitch and Usam, I'd like to hear your thoughts on it. Even if Congress were to pass a new law, at least some of the proposals I've seen don't call for full federal preemption of state privacy laws. So certainly some aspects of the CCPA might stay in effect, as well as other state laws.
I think the interesting challenge, I can go in a completely different direction you are, is that we're seeing other countries enact strong privacy laws, and those laws have extraterritoriality provisions in them. So, the United States could remain an island in the world and do business in the United States one way, but companies who are multinationals are going to be forced to go off and implement stronger privacy protections for their clients and visitors who are residents of other countries or other areas like the European Economic Area. So does the company go off and say, well, in the United States, I don't have to go off and provide certain privacy protections, but the rest of the world, and already there's at least a dozen countries that have implemented laws that are very similar to GDPR, are we going to do that? Or are we going to go off and say we're going to have one uniform way we're going to interact with our folks that we talk to?
And I think that's a good point.
Tom, I think what Mitch just said applies also within the U.S. Because I'm just looking at the slide right now. What you're looking at, if you're going to be doing a business in California, or if you have any internet presence and you expect to have anybody visit your site from California, you're going to have to comply. So even if the feds come up with more with any kind of privacy scheme, as long as it doesn't preempt California law, you're probably going to have to comply with the most strict state law, whatever that state is, and most likely it's going to be California.
And I think, some I've heard people talk about just not doing business in California, but you probably do that at your peril. California is the 5th largest economy in the world, behind 4 other countries. Excuse me. So it is something to keep in mind. Certainly the trends are going toward more data protection, whether the United States as a whole follows or not. So whom does the law protect? The CCPA applies to any natural person who's a resident of California. Customers, employees, visitors to a company, internet site, or building. So that could be somebody who's into a computer at your reception desk, or somebody who's signing a visitor log with certain information, right? Contractors and independent contractors, and vendors. So it is not just your customers' data. Now, it doesn't apply to the collection or sale of data that's wholly outside of the state of California. So if the business collected that information while the consumer was outside of California, no part of the sale of the consumer's personal information occurred in California, and no personal information collected while the consumer was in California is sold, then it isn't covered by this. The CCPA is a significant expansion of current privacy regulation in the U.S. because my understanding of it, this is a general privacy law. It doesn't just apply to electronically collected information. And there are key pieces to it. But let me start by saying it applies to all companies that collect California residents' data and have annual gross revenues in excess of $25 million, or annually buy, receive, sell, or share for commercial purposes personal information of 50,000 or more California consumers, households, or devices, or derive 50% or more of its annual revenues from selling consumer personal information. Now, what's interesting about that is that people have calculated that the 50,000 consumer threshold could be pretty quickly met by companies who accept credit cards or run websites, because each unique card collected and site visitor IP address will count toward that number. Some commentators have noted that all a business needs is about 138 data points per day to get you to that 50,000 number. Also, as a side note, interestingly, it seems like more organizations appeared under the CCPA than were under the ballot initiative, because the legislature actually lowered the threshold requirements for gross annual revenue and sale of personal information. The law applies to companies directing others collect the information on their behalf, controlled affiliates, and companies that share common branding. Now, it also covers parties that are sole personal information as successors in interest. So keep that in mind if you are taking over another business. Types of information.
Danielle,
Yeah.
quick question. So just to be clear, this does not apply to any nonprofit organization. So that entire sector is exempted from this, right?
The entire sector is exempted as long as they're not selling any information for profit. So my understanding, and I've read a couple opinion pieces, that the nonprofit category is still a little bit up in the air, which I thought was interesting. And I think Mitch already noted there already have been some amendments, and I believe there probably will be more. My understanding is that nonprofits aren't covered, but I have also, like pieces of this law, people have opined, well, that's not completely clear, depending on what they do with the data. But yes, the intention is not to cover selling the information for profit. All right. So the information covered under the CCPA is personal information of California residents, online and offline. This is more of a general privacy law. It's not just related to electronic internet privacy. Personal information under the CCPA is much broader than you typically see in state statutes. Essentially, any information that could identify an individual or be used in conjunction with other information to identify an individual is protected. So what I want to stress, I'm going to actually read the definition of personal information. I think it's interesting. Information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. And to me, this piece is an interesting addition because we haven't really seen that before as far as I'm aware. I think this is not just limiting an individual consumer. I also want to say that there were some technical amendments signed into law recently, and there was a lot of scuttlebutt about how the CCPA might infringe on First rights. Now, I know that the technical amendments clarify that consumer rights and business obligations enumerated under the CCPA do not apply to the extent they infringe on non-commercial activities of the press. There's still some questions related to First Amendment rights of businesses. Okay, and here's some examples of personal information. You've got identifiers. Some of these we've seen before in other state laws, certainly. Online identifier of internet protocol address. We underline that because that is something that we see in other country data protection legislation, but it's relatively new here. Things like social security number, driver's license number, passport number, those aren't surprising. Those are pretty typical. And also, protected personal information would include characteristics of protected classifications under California or federal law. Also, commercial information is also protected under the CCPA, including records of personal property, products or services purchased, your history, your consumer history, or tendencies, which is interesting. I think it's an interesting category. I'm not aware that there's any other legislation in the U.S. certainly as broadly defined as this. Mitch and Usama, are you aware of any?
No, this is so broad. It might as well just say everything about a consumer, period.
Because the problem is it says, if it can be inferred, I mean, that's pretty much everything.
Biometric information, I know that there are a few other states, notably Illinois, that have already legislated protection of biometric information, as well as, to Usama and Mitch's points, internet or other electronic network activity information. I mean, that's so broad, again, has potentially a very large application. Geolocation data. Now, this is the first time I know that I've seen any legislation regulating geolocation. A lot of businesses rely on geolocation, have struggled with how to obtain consent and the issue of what can actually be done with the geolocation data. I would recommend that businesses that use that data carefully consider their obligations under the CCPA to the extent you can make them out, especially thoughtful about providing opt-out mechanisms. You know, before our call started today, before our webinar started, we were having a lively discussion about whether employment information is protected. And one thing I would say is that a lot of employers we work with who give their employees vehicles, for example, use geolocation trackers. So it's something to think about. Geolocation information is pretty widespread at this point, and it is something to be thoughtful about if that's something you use within your business. All right, and then finally, inferences drawn from any of the information identified under the personal information subdivision. As Mitch said, it's pretty much everything. It's very broad. There are some limited exceptions for the category of personal information, and specifically publicly available information. But one thing I find interesting about this is, so for example, let's say my name is listed in the white, my phone number. That's public information. But when I'm filling out an application for you or I'm interacting with you, you don't necessarily know if my phone number is public information. You know that you're getting it from me. You don't know where you got it from. Also, the CCPA does say that information that is not used for the purpose for which it was publicly used is covered, protected under the CCPA. So I think there's some tricky aspects to this to keep in mind if you are thinking, well, this person's telephone number, you know, telephone numbers are published online or in the white pages. To the extent people use this, and I think even the white pages are online now. Mitch, Usama, do you have anything to add about that?
I think the message here is that people need to understand that this is very complex. It's a moving target, but January 1st, 2020 is not very far away, and people need to start understanding what they need to do, starting with a full data inventory and data flow process map so they can understand what data they're collecting. You were talking about geolocation data a second ago. You know, do you even know whether or not the various platforms that you use collect geolocation data that you may not be using? The fact that you're not using it doesn't absolve you from responsibility for complying with the law.
Well, that's a good point. Mitch and I were recently advising a very large, sophisticated international client, and we were sitting in a conference room, and it was clear in the meeting that they didn't even realize no one person there had their arms around all of the data that they collected and kept and where it was kept and how it was accessed. You know, and this is a company that's pretty sophisticated, has staff devoted to information gathering and collection, and they have their arms around it. So it's not an easy issue. It's pretty complicated. Let me note one more exception before I turn this over to Usama. If you have information that's been aggregated or de-identified, so it cannot reasonably be related back to a particular consumer or device or household, then that is also an exception. Now, to fall within the exception as a business, though, you have to implement technical safeguards to prohibit re-identification. All right. It's all yours.
Yeah, thank you. Before we go on to the next topic, I mean, one of the things you just mentioned that I think is very important and is actually a big change in the law in California is that this is the first law on the books that covers all paper and electronic information from whatever source you collected. If it fits within these categories, it's covered. Prior to that, you know, for example, if you know, a company is trying to determine whether it had a data breach or not because it had a break-in last night and paper files were stolen. Well, that's a very easy question to answer. No, the data breach statute under you know, in California only applies to electronic information. It doesn't say that if paper files were stolen that contain Social Security numbers that you have a data breach on your hand. Well, this law now, I mean, this is not a data breach notification statute per se, but it's much broader. It's covering a lot more information than just electronic information. Okay, so there are a lot of rights to know about that consumers now have and obligations that that come from it. The first is the right to know. We'll go into each one in more detail. So let's go to the next slide. Okay, so companies must be able to provide consumers with what information the company collected, holds about the consumer, among other things like the purposes for which the information was collected. And this goes back to what Mitch was saying. This means you need to start inventorying what information you're collecting and what information you're holding, because as we'll get to know in later slides, there's going to be times when you have to disclose to consumers, or you have to respond to a request from a consumer to tell them what information you've collected, what information you have on them, for what purpose you are collecting the information or have collected the information, and you should be able to map where all that information is, and also identify what it is being used for.
And that mapping is also, excuse me, that mapping is also critical if you have a breach.
Exactly, and that's always a good idea to do before a breach as opposed to after a breach, and that way you try to prevent the breach from happening in the first place. A very big distinction here is whether the information is being disclosed or sold, or both. We were debating earlier about whether information that is collected for purposes other than selling the information is covered in terms of the disclosure requirement that we'll talk about. But let's go to the next slide and we'll talk about it there. So businesses will have to inform consumers at or before the point of collection. That's a very, very important language in here, regarding what categories of personal information they collect and the business's purpose in collecting that information. That means that at the point of the transaction, if it's a consumer transaction, for example, you have to make sure you are informing consumers at or before that point what information you're collecting and what the purpose of that collection is. Applying this to employers, because I represent employers. I work at an employment law firm. When it comes to employee records and employee information, a question I want to pose to the other panelists that we were talking about earlier so that they can share their input is how would employers, do employers have to now notify employees every time they're collecting information from them that we have to share this information with our payroll provider, with our benefits providers, with these third-party providers for purposes of administering benefits and payroll? What do you guys think? Mitch, Danielle?
So I think that there's a lot of things that are still unclear. In theory, the Attorney General is supposed to issue some guidance. In fact, the law specifically requires that. It says that the enforcement and the amendment that they just passed changed that the enforcement of the law cannot occur any earlier than 6 months prior to when the Attorney General releases the guidance on it. But we don't know how complete the guidance is going to be. So I think there's a lot of stuff that's still up in the air. My interpretation is it covers all that, and I think employers also obtain information from third parties about employees, such as credit reports and criminal background checks and things like that. So that's also, in my opinion, also covered. And I think the thing that people need to consider is, if I have to go off and hire Fisher Phillips to defend me in court, in a case where somebody brings an action, either the Attorney General does, or in case of a breach of private right of action, am I going to be able to defend what I've done? That's really, I think, the gold standard that you're going to have to deal with.
Even before this law, my general recommendation under this general privacy law in California is that employers should have some sort of privacy policy or disclosure that they give to the employees, whether at the hiring stage when they're collecting information and paperwork, to inform them of what third parties the employer is sharing information with and for what purpose. Just like you have to get their consent to get a background check run on them, on employees. It's always a good idea, just from a general practice point, with or without this law in California, to inform employees in writing that their information is being shared with, or certain information that the company's collecting on them is being shared with payroll providers, third-party providers, whether you're working with the PEO, benefits administrators, etc., for purposes of managing the employment relationship and managing payroll and benefits and all sorts of things. Generally a good idea. Whether that's going to be an actual requirement moving forward under this law is unclear, but that's something that I think can become clearer, hopefully, with guidance and regulations that will come out from the AG. The second point of this slide here is that businesses are now going to have to provide information about the personal information they collected whenever they get, quote, a verifiable consumer request. What is a verifiable consumer request? Well, that's still unclear. Generally, it's going to be a request that from which you can really verify that it's the actual person and it's not someone else requesting the information for them, or it's not someone trying to steal information. So it's how to it requires a process for verifying the identity of the consumer that is requesting this information. So exactly what that means and what the standards are going to be, that's unclear. We're hoping that that would be clarified by the Attorney General when they issue their regulations and guidelines as part of this law next year or the year after. Next slide, please. So let's say you collected information on me as a result of my interacting with your website. How do you verify that it's really me and that I'm not a hacker and not an imposter? That's really the question. Different companies have come up with different ways to do this. I mean, there may be maybe you have to do a dual-factor authentication of some sort and have the person put in a code after they get texted a code on their cell phone that you've collected before. I mean, there's a number of ways to do this that people have used to verify the identity of people online or through through the internet. It's not 100% foolproof every single time, but there are various different ways. So it's going to be interesting to see whether the government in California sets an actual standard that you're going to have to follow, or if it's going to be just do whatever is the best practice under current technology and feasibility.
One of the challenges you have is that the law says you cannot require someone to go create an account on your website as a result of making a request. So some of the things that you might be able to do if someone had an online account, you won't be able to take advantage of because you can't force them to create an account. That's
right. Yeah. So how do you verify that it's the right person asking you for the information if you haven't even been allowed to collect certain information on them that would allow you to go ahead and verify their identity? It's kind of it can get complicated once you go down that rabbit hole. The right to know creates multiple compliance challenges for employers and companies, businesses that fit within this law in California. Like we've been talking about, you have to make sure you're doing a thorough inventory of data, everything you're collecting, where you're storing it, what uses you've had for this information. You also have to make sure you're developing policies and mechanisms to ensure that you're processing the information in a manner that's consistent with the purpose that you've informed the consumer about for use of the information. You have to make sure you have policies and procedures and compliance mechanisms to inventory, to identify the various disclosures of the information. And I mean, I imagine this is going to require, for companies that don't already have this, is going to require potentially an investment in infrastructure. If that infrastructure is not there, whether it's a software platform or some other way to make sure you're tracking and managing all that data, I think that's going to be where we're headed with this. Is at some point, if you deal with so much information, you're going to have to invest in a system that allows you to comply with this.
And also remember that employees tend to collect data on their own, and store that. So if someone makes a request to delete your information and employees have made copies of it and have it on their laptops or their phones, or whatever, the data inventory needs to include all of that as well.
Yeah, and that's a good point, because we see that a lot, and I think that employers are going to have to be thoughtful about all the ways in which information comes in. You ensure that you have your arms around all of that, because we certainly see that with departing employees. Usama, I know you see that in the practice area. Definitely.
Yeah. Mm-hmm. Next slide, please. So information collected by companies in California that have to comply with this law, or will have to comply with this law when it becomes effective. Information must generally be used for companies' operational purposes or other notified purposes, meaning you have to have already notified the consumers these are the purposes for which we're using your information, and you can't suddenly start using it for a different purpose without disclosing to the consumer that we're going to start using your information for this other purpose. Businesses cannot use the data for a purpose that is not disclosed, so it definitely requires an additional disclosure if you're going to add something. So it's always a good idea to just be comprehensive. I mean, you may even just use some of the catch-all categories in some cases. Businesses cannot collect additional categories of personal information without providing notice that they're going to start doing that. And so this is, I think, an area where we'll also see some hopefully guidance that will clarify exactly what those regulations are, or how specific do you need to be with identifying the purposes for which you're collecting the information, or can you just use the purposes, based on the definition of business purpose within the statute, which provides a number of categories where you can potentially just pick those categories, and then you don't have to worry about it. But we'll see whether there's going to be a level of specificity required in what you notify the employees about. I mean, can you just say we're going to use this for operational purposes? I mean, that seems kind of broad, versus being as specific as this particular piece of information is being collected for payroll purposes and to comply with payroll issues. Next slide, please.
Well, let me just say that, a lot of in the line of work that we do advising employers, we see a lot of employers collecting information they don't need, especially in the recruitment process. They don't need it yet. They anticipate they might like to have it someday. Same with businesses. I think it's a good idea to understand why you're collecting the information you're collecting and what you have it for. I don't think it's a good idea to collect information simply because you think at some point you might like to use it, or even to keep information beyond what you're legally required to keep for the duration of time that you're required, because that's more information that you have responsibility for. So I would urge everyone who's in a position to get their arms around that kind of data and to understand, why are we collecting this? Do we even need this? And certainly, do we need to keep full recruitment information beyond, unless it's legally required, beyond the period of time that it could be used by us?
That's a great point. This applies not just to electronic data, but paper data. In my electronic discovery work, I can tell you that the more data you keep beyond what you're legally required, the higher your costs are in litigation. Because if you've kept it and suddenly you're being sued and the information is relevant, well, guess what? Now we're going to have to search it, review it. You're going to have to pay a bunch of lawyers to review all these documents that you've retained for really no good reason. So it's definitely a good idea to disposition or destroy data and documents, paper or electronic, after a certain point when they're no longer needed, whether it's for legal compliance or when there's really no business reason to maintain those documents.
You make it sound like paying your lawyers, Usama.
Right. Yeah.
Also remember that the discovery process includes data that is stored on employees' laptops, employees' phones, and in the cloud on cloud service provider systems.
Right. So the right to deletion, consumers now have the right to have their data deleted upon request. Of course, unless if the business refuses to delete the data and has a legal basis for that refusal. There are limited circumstances when the law would deem it necessary for the business or the service provider to maintain that consumer's data and to not delete it despite receiving a request, a verified request from a consumer, and you know it's from them. And so let's look at the next slide for those particular reasons. For example, you don't have to delete data if you need the data, the particular consumer's data, to complete the transaction or a reasonably anticipated transaction with that consumer, or any transaction really. If you need the data to find, prevent, or prosecute security breaches or illegal activity, if you need the data to debug, to identify repairs and issues in your system that need improvement. This last one is interesting because this deals with the issue that Danielle mentioned earlier: exercise free speech of the business or a third party. That brings into question of, under what circumstances would you need to maintain consumer information in order to exercise free speech? And why is it that there was a perception, or is it true that that requiring a business to delete information that they may use for their exercise of free speech is a violation of their free speech rights? I mean, those are constitutional questions, probably beyond the scope of this presentation. But Danielle, I'd like to hear your input if you have any input on this First Amendment issue that came up, that resulted in some changes actually recently in this particular law.
Yeah, I know that it resulted in changes, technical amendments specific to the press. I think there is some question that, and some thought that the law might actually be vulnerable as it applies to First Amendment rights of businesses. It's so early, it's hard to tell. I think there will be, on so many of these areas, additional amendments.
More examples on the next slide. You don't have to delete information if you need the information to engage in research in certain cases. It's also unclear what that means. You don't have to delete information, and it'll become clearer hopefully when we get more guidance and regulations from the AG. If you need the information for internal uses that are reasonably aligned with the expectations of the consumer based on the consumer's relationship with the business. Now that's lawyer speak if I've seen any. What does it mean to be reasonably aligned with the expectations of the consumer, and how do you evaluate that in the context of the consumer's relationship? I can tell you in the employment context what this means. Well, in the employment context, perhaps if an employee submits a request that I need my payroll information deleted. We're required by law to maintain in California. That also fits in the next category. We're required to keep your payroll data for 4 years. But even beyond that, we need data that's older than 4 years for your payroll for various reasons: historical reasons, benefits-related reasons, administration of various benefits that may be tied to longevity. I mean, there's all sorts of reasons arising out of the employee's relationship with the company that would require the company to maintain certain information about the employee, despite the employee's request to delete the information.
But what if, for example, what if, for example, you're collecting social media information about your employees? Is that reasonable? Is that within the expectations? Have you disclosed that?
That would be that's going to be a case by case. That depends. What if you're collecting that information as part of an investigation into sexual harassment by employees, and you have to collect a bunch of social media stuff on them? And how long do you keep that? Well, investigation files may have to be kept for a while. What if there's litigation that's going on for years related to that? It's really going to depend on the circumstances. You also don't need to delete information upon receiving a request if you need the information internally and to use it in a lawful manner that is compatible with the context in which the consumer provided the information. That's also similar to that other category earlier. And then deletion requests also apply to third-party service providers that you share data with. So for employers, it applies to payroll providers, third-party vendors, accountants that you may share information with about employees or about consumers. Third parties may be liable even if they do not qualify under the definition of a service provider. That's interesting, because if you're a third party and you don't comply with this law, there is potential liability, and that's also an area that's unclear. There's actually not a lot of language related to that in the statute, and it's too early to tell exactly what that means and to the extent to which there would be liability against third parties. But just be aware that that's a possibility. Next slide, please. The law also gives consumers the right to opt out, the right to say no to the sale of personal information. So if the company is collecting information for the purpose of selling the information, then consumers have to be given the right to opt out, to not sell their personal information. They also have a right to equal service and price, even if they exercise their privacy rights. So, if a consumer opts out of the sale of their information, you can't just mark up their prices and charge them a surcharge for not allowing you to sell their data. Next slide, please.
But there is the option for a business to pay a consumer for their data, right? Isn't there some option? CCPA?
Yes.
That was related to loyalty programs in particular, where you, in exchange for giving up information, like at the supermarket, for what you bought, they're going to give you free groceries or fuel points or whatever. They made that change to make sure that that remained legal, because under the original drafting of legislation, that was not legal anymore.
Right. Yeah. No. Exactly. And so this is something that Mitch brought up. The business cannot require a consumer to create an account to obtain a copy of their data, which may mean that you have to mail the data in some circumstances. And that's going to, we'll have to know how do you provide information? How do you respond to a request? How do if you don't necessarily have all of all of the mechanisms for contacting the consumer. Next slide, please. The right to be free of discrimination. Generally, businesses must provide equal service and pricing to consumers, regardless of whether they exercise their rights under this act. So, this is going to be interesting, because California, one of the most litigious states in the history of the world, we'll see how that goes. I'm sure there's going to be test cases. I'm sure there's going to be potential class actions. I'm sure there's going to be, in the employment context, employee attorneys who may try to make clever arguments that you discriminated against the employee because they declined to share certain information, or they wanted to opt out of certain providing you of certain information, or any other way exercising their rights under this act. It's going to be interesting, in the employment context for me, because what if the employee is wants to opt out of sharing information, right? And you need that information in order to employ them. Well, we were talking about this earlier offline, that for a lot of employers, it could be potentially a condition of employment that the employees provide information. We can't employ you unless you provide us certain information. In some cases, that information is required by law, but there are also a whole slew of categories of information that that employers will need for business-related purposes from employees. And if the employee doesn't provide that information, well, the only other option is you can't work there anymore. Well, this may turn into a discrimination claim, potentially, if they were trying to exercise their rights under the law. So that's going to be interesting to see where that goes. And then the second point here is what Mitch was talking about earlier as well, provision to allow businesses to pay consumers who allow greater use of their information. Next slide, please. So these are all the things you need to keep track of. So it's important to think about developing a system, process, investing in software that tracks all of that. Next slide. So whether you're a service provider or not, you should also know what service provider obligations there are under this law. If your responsibilities under the service provider model appear to not be well thought out in this law. So that's one area that we're going to be looking for more guidance from the AG on. There's no requirement necessarily for a written contract or a particular risk management process. There may be once the AG comes out with their guidelines, but the thing is, you will likely get sued anyway if the vendor screws up. So you should protect yourself and not rely 100% on the vendors and service providers to make sure that they're complying. You should, always exercise due diligence in making sure that your service providers, your vendors, are actually complying with the law and don't just take their word for it. Have them certify, put it in the contract, include indemnification language in your contracts with them, to make sure that they're complying with this kind of law. Next slide. Is it okay to over-disclose? Probably not, but this is also not yet tested, and we'll see if the AG comments on it. I doubt this will be an area they'll talk about, whether there's over-disclosure. Do you guys have any other thoughts on this one?
No,
Sorry,
I think
my mute button keeps getting stuck. I don't at this point. I really, it's something that I've looked at. I don't really know. It's up in the air right now.
hopefully we'll get some guidance.
Let's go to the next slide. Noncompliance will get you civil penalties from the Attorney General if the Attorney General brings an action against the company for up to $7,500. It starts at $2,500, but it's up to $7,500 per violation, and that's if the AG brings an action. The law also creates a private right of action in case of a breach resulting from non-compliance with this law of up to $750 per consumer per incident or actual damages. This is a private right of action in the event that the company fails to maintain reasonable security measures, and then that results in an unauthorized disclosure of that information to an unknown or third party that doesn't have authorization to have that information. So you have a data breach, basically. This law creates a private right of action that can be very significant because it's up to $750 per consumer per incident or actual damages. So it can actually be more if there are actual damages that are higher. There is a 30-day right to.
With the $750 right of action, you do not have to prove that you were harmed.
Correct. This is one of the biggest issues with this law that a lot of business advocates were lobbying against before this passed, and hopefully there would be some changes or some corrections to make sure that plaintiffs would at least have to prove they were harmed. Sometimes information may be disclosed when there is no harm. For example, sometimes information may have gone out to a third party that accidentally. And then that person says, I don't need the information. I deleted it. I'll certify that I deleted it. And your investigation concluded that that person no longer has the information and that you've verified that. Maybe even they'll let you see their log into their account to make sure it's no longer there. And you verified that you've put the cow back in the barn, so to speak. Regardless of that, there may still have been a data breach. There is no safe harbor under California law for, unlike in many other states, where if you investigate and find out that there is no likelihood of any future harm because you've recovered the information or you've been able to confirm that the person who received the information, to whom the information was disclosed, no longer has it. And so that's a situation where nobody has been harmed. There is no identity fraud. There is no identity theft. And yet that person can still sue and get an automatic private right of action for damages just because their information was leaked. That's to use a legal term, ridiculous. But hopefully that might change, or people might push back on that, or there may be some regulations or guidelines that would correct that. 30-day right to cure requires a plaintiff to send a letter to the employer prior to filing a lawsuit, giving them 30 days to cure if there is a violation that can be cured. But a lot of this stuff just can't be cured once there is a violation or a breach. You know, but they can, if they've been harmed, if there's been monetary harm as a result of a breach or violation of this law, they can just go straight to court without giving you the 30-day notice to cure. Next slide. The law authorizes the Attorney General of California to adopt regulations, so there's going to be a lot more to come. And there are already revisions in the works, including some that will be talked about later in this presentation. Next slide. As we've mentioned, the good news is that it doesn't go into effect until January 2020, but like Mitch said, that can come very, very quickly if you just blink. Enforcement does not start until July of 2020, but that can also can come very quickly. The bad news is there's a lot of work to do if you are not already up to speed on policies and procedures and mechanisms to make sure that you're tracking all of the information, to whom it's being disclosed, for what purposes, et cetera, as we've talked about.
And I'd like to add, don't forget that the look-back period means that consumers can start asking for information regarding the information you're collecting about them starting in 2020. So you'll have had to have been tracking that information prior to that time point.
Right, absolutely. So the billionaire who was proposing this law said he will put another initiative forward if the legislature weakens the law too much. He's also considering assembling a group of engineers and technical professionals to help the AG implement the law. Will be interesting whether the AG actually uses their help, but there will be more to come. I'll turn it back over to Danielle.
Thanks, Usama. Excuse me. So there's a lot of material here, and we're getting up close to the end of our time. Probably should have allotted more time for this. I see that a lot of people have asked questions, and those that we have not answered yet, you can always email us afterward. I know one question that we've been asked quite a bit is whether this presentation will be made available. I know that after the webinar, our firm will be sending out an email thanking you for attending, and we'll ask that they attach a copy of the PowerPoint. And you can certainly follow up with any questions that weren't answered. Also, the session is being recorded, and you can find that on our website after the presentation is over. So I'm going to talk very briefly, given that we have limited time, about the differences between GDPR and the CCPA. This may not affect all of you, so I'm not going to go into great detail, but I know a lot of our clients have asked. I've already put all this work into GDPR compliance. GDPR, in case you're wondering, is the General Data Protection Regulation that went into effect in Europe, the European Union, at the end of May of this year. And in general, it's important to understand the who and what that are protected are similar under the GDPR and the CCPA. But there are a lot of differences in terms of enforcement mechanisms. Under the GDPR, there's some pretty stiff penalties if you don't comply. And I think the individual protections under the GDPR are more expansive. But you're looking at, the GDPR has 173 paragraphs of recitals and 99 articles. So it's pretty big, pretty broad, whereas the CCPA has 14 recital sections and only 19 individual sections underneath that, with some of them with numerous subsections, but there is a big difference. Some areas I want to highlight is the regulator staff. The GDPR has a very big staff of enforcement officials. Under the CCPA right now, it's very limited. I read a couple estimates that probably going to cost $50 to $60 million for the state of California to get their enforcement personnel up and running. Given that, I would expect there's going to be pretty aggressive enforcement because they're going to have to get some penalties in order to pay for the program. Range of data covered is very similar, so if you already are taking care of this for the GDPR, hopefully you don't have to make too many changes. Some of the consumer disclosures are going to be very similar, probably doesn't take a lot of tweaking. there is a consumer right to be forgotten under the GDPR. Under the CCPA, I don't know if it's so much a right to be forgotten as it is a right to be deleted. Interestingly, under the GDPR, you have the right to have your information corrected if it's incorrect, but that is not a provision under the CCPA, at least not as of right now. I think Usama has already adequately talked about the right to a copy of your data and the format it needs to be in. It's very similar to the right to a rights under the GDPR. And we've talked about this before our call, Usama and Mitch and I, about a consumer's right to stop processing and what that might mean to an employer, for example, and whether employees are even covered under the CCPA. And clearly, if you are asked by an employee to stop processing their data, you may not be able to keep them as an employee. Now, under the GDPR, opt-in is required, whereas that's not the case for the CCPA unless the individual's under 16. We didn't talk a whole lot about that, but in general, under the CCPA, opt-in is not required. It is important under the CCPA that you have required language on your website homepage related to selling of personal information. People need to be able to opt out pretty easily, and that's not a requirement under the GDPR. Under the CCPA, Usama talked about the right to be free of discrimination. That's not explicit under the GDPR because they don't have the same civil rights laws that we do. And so it is a little bit different. And I think civil rights class actions are virtually unknown in Europe. So it is a little bit different of an animal. Nevertheless, the penalties are pretty stiff. As you can see, the regulatory fines under the GDPR are pretty high, potentially for noncompliance. Okay, with that, I'm going to turn it over to Mitch.
And if I unmute my microphone, it'll work better. So the first set of changes has already been approved. The governor either has signed it by this point or is about to sign it. And they're mostly technical corrections. They do things like make sure that HIPAA exemptions and other federal law requirements where there is a potential conflict with federal law, conflicts with references to things that are protected by the Constitution. Those are all removed. Next slide, please. It says that we talked about July 1st, but really what the amendment says is 6 months after the Attorney General publishes their guidelines. So if the Attorney General gets their act together and publishes their guidelines on October 1st, then 6 months from that, which is earlier than July 1st. So it could happen, the enforcement could happen prior to July 1st. And as Danielle pointed out, since there's a look back provision, you better kind of start thinking about this data going back in 2019 because you're going to need to do that. And it really does say that it doesn't supersede the Constitution. Now, I would anticipate in the next year's legislative session, there's a lot of lobbying going on because there's a lot of people whose business model is really impacted by this. You know, the large social media and other companies, internet companies who don't charge people for their services, but sell their data as a way to earn a living. And that could be as a result of just targeted advertising. So anticipate that there will be some changes, but I would not anticipate, and even looking at the stuff that's going on in Washington, the lobbying that's going on in Washington right now says, that even in Washington, they understand that implementing a weak privacy law is really not going to be tolerated by the states and also by consumers. So assume there's going to be some changes, but it's probably going to be tinkering around the edges as opposed to making fundamental changes and starting to plan doing things like data inventory and incident response and things like that are critical. So this is not going to be easy, but certainly reach out to any of us to get assistance and start budgeting for the implementation. Danielle?
All right, so we are at noon. We thank everyone for attending. Again, a copy of the presentation and a recording will be made available. And if there are any questions that we didn't get to during the presentation, please feel free to email any of us individually. Thank you, everyone.